All right, hey, welcome. Hit chapter 5 here. This is a long one. It's civil rights. We're gonna contrast civil rights to civil liberties, which we talked about in chapter 4. But it's buckle up. It's gonna be a long ride here. So when we look at civil rights, what we're really looking at is just a guarantee from the government that we're going to treat people the same. That people of one race or one gender or one anything's going to be not treated differently than somebody else. All right. And so we look at where we get the ideas of civil rights in our founding documents. Obviously, in the Declaration of Independence, everybody is created equal and endowed by our creator with certain inalienable rights like life, liberty, and the pursuit of happiness, right? And so that's Declaration of Independence. We also have the Fifth Amendment from the Bill of Rights, which guarantees equal treatment, due process on the federal level. The 14th Amendment that comes about after the Civil War, which promises equal protection and due process on the state levels. And then the 8th Amendment, which is freedom from cruel and unusual punishment, which kind of falls into that civil rights, civil liberties net. I think it could go either way there. And then you have Bowling versus Sharp, which says the Supreme Court ruled that discrimination can be justifiable as long as it doesn't violate due process. So I think the book does a good example of like the visually impaired. So should someone that's visually impaired be allowed to drive a vehicle? Probably not if it's going to cause damage to somebody else or could cause damage to somebody else. So you have that, right? And you have other laws that treat people differently, like you have to be 16 to drive or 14 to get a permit. Smoking, vaping, voting all have age restrictions. And so those are legal forms of discrimination based on age. But there's not a top end age for those things. So that's that is met by it. Those fall into those ideas of civil rights, right? And then, just your abilities. Private colleges, public colleges, sometimes they have admission processes. I know if you transfer into like the University of Kansas from another college, you have to have a certain GPA to be accepted. Obviously, like Harvard or Yale, those more private, more competitive schools have higher admission standards than others. But basically, the Supreme Court ruled that laws can treat people differently. The laws can treat people differently, but there has to be a reason. And the first lowest level of tests that are qualifications that some of these places have to meet would be the rational bias test. Like, is there a reason for it? Like visually impaired people shouldn't drink and shouldn't drive. Nobody should drink and drive. People under the age of 21 probably shouldn't drink. I would be in favor of them of the government just if when you're 18 you're an adult, then everything should be legal at 18, or changing that classification away from 18 to 21. But I mean, people smarter than me figure this out, so who knows? The step up from rational bias would be intermediate scrutiny, and this is typically used when cases face gender discrimination, and it has to show why that treatment is justified. Like women can't be excluded from military colleges, but they are not subject to the draft. And I mean, I guess why would be that historically women haven't been forced to register for selective service, so it's kind of a tradition in the United States not to do those things. But there's a rationale behind that. Pause. Resume recording. All right, so we have rational bias or intermediate bias. And then you have the highest level of scrutiny, which is strict scrutiny. And this typically falls into racial discrimination cases, racial, ethnic, religious. It puts a heavy burden of proof on the government that A, there's not just a reason for it, but there's a compelling reason for the law. And if there is a law, that law has to be so narrowly tailored that it only meets the specific interest or the only compelling reason. And it does so in the least restrictive way, right? So there has to be a non-discretionary way to meet a goal. If there is that non-discretionary way to meet this stated goal, then it should be implemented instead of a law that discriminates. The book also talks about affirmative action. Affirmative action is kind of a hot button topic over the past decade and a half, or even when it's longer than that, but whatever. And these are programs and policies that are put in place by the government to help minority groups that have faced historical discrimination and to give them a leg up in certain hiring practices with the government. Sometimes, like, the government will require a certain amount of minority companies to win government contracts. You might see, government companies that do business with the government have to employ a certain percentage of minorities in the workforce, those types of things. And so those jobs necessarily aren't awarded on merit, but they're awarded on race. And so some people argue that that's reverse discrimination. We'll see how that works out as we move forward in your lifetime, probably. Okay, so why do we need civil rights in the Constitution? Well, when we look at the Constitution and where the country was founded, not all social groups are treated equally. Obviously, groups are not all treated equally. Men are treated differently than women, especially white men are treated much better than everybody else. And in fact, when the Constitution is written, white men are the only ones that are taken into consideration. You have the 3/5 compromise. You have the 2/3, the 3/5 compromise, in which African-American slaves, people held in bondage, enslaved Africans, are counted as 3/5 of a person for taxation purposes, which the tax never gets levied on those people, and for representation purposes. Women aren't guaranteed any rights in the Constitution. Now, women do have some rights in the American colonies and in the early American government, but not protected by, not specifically listed in the Constitution. Native Americans are not considered citizens, so therefore they're not protected by the promises of the Constitution. And freed blacks, free African Americans are not considered citizens, and so they're not given rights. And so really for that first, 90 years of our, or 80 years of our existence before the Civil War, civil rights are very restricted just to white people, white males. And so as nation matures, as after the Civil War, we have the Civil War that finally answers the question of slavery. And to bring an end to slavery, we passed the 13th Amendment. Radical Republicans take control of the Congress following the Civil War. And they lead us through a period of radical reconstruction in which they passed the 14th and 15th Amendment. And the 14th and 15th Amendment are the first times that the government really kind of starts to extend civil rights outside of what was originally promised in the Constitution. And so you see the 14th Amendment promise equal protection across state lines, applies the idea of due process across state lines. And the 15th Amendment gives African-American males the right to vote in federal elections. Okay. And the reason for the need for the 14th Amendment is really the fact that following the Civil War, there's this big question about what's the South going to be like? Are we just going to end slavery and just put the Union back together and just move forward? Or are we going to completely remake the South? And so there's some historical debate on this. What should be done? The first, Lincoln, I guess I should point out, President Lincoln believed that the South never had a legal right to leave the Union. And so therefore, they never left. And so there was nothing to put back. And so Lincoln, once the war was won and the Union was reunified, then he was pretty much happy just to move forward and move forward with the country. And of course, we know Lincoln was assassinated, and then Andrew Johnson takes over, and Johnson runs into problems with a radical Republican Congress. And the radical Republicans in Congress, they want to remake the South. They want to get rid of racial discrimination in the South and move forward that way. And so one of the things that they're battling is this idea of black codes. And black codes were laws that were written in the South following the Civil War, in between the period of when the Civil War ends and when Reconstruction begins, radical Reconstruction or military occupation begins. Black codes are put into effect. And so basically what black codes are, they're just laws to limit the freedoms and rights of African Americans or the freed slaves in the American South. So it's going to require African Americans to work for somebody, specifically a white person. They can't travel after dark. They can't travel without papers. They can't vote. They're excluded from public education. They're going to face violence from whites. And these ideas are upheld in the controversial Supreme Court decision of the Dred Scott versus Sanford case, in which Dred Scott, who was a slave, sued is that part of this? No, sues his owner for his freedom because he was transported across lines multiple times and left unattended multiple times in freed states. And so his argument was that once his owner took him across state lines, specifically, like I think he goes into Wisconsin, and Wisconsin is part of the Northwest Territory that was established, and slavery was forbidden in the Northwest Territory. And so once Dred Scott travels into Wisconsin, he argues that he is now a free man and that he shouldn't have to suffer the indignity of bondage. And the Supreme Court rules that African Americans, freed or not, are not American citizens. And then furthermore, they argue that Congress doesn't have the power to limit slavery in new territories, which opens up this possibility of popular sovereignty and ending things like the Missouri Compromise. It opens up a whole new Pandora's box of questions about slavery, and then of course those get answered in the Civil War, so we don't have to question those. Okay. We talked about that, the 14th and 15th Amendment. They're the work of that radical Republican Congress, and what those do. And so, the book talks about 3 ways to identify civil rights issues, right? The first one is which group is facing discrimination, what rights are threatened, and then what can we do? What can the government do? And is it a realistic fix for the government to fix that situation? Obviously, if we look at African Americans and their plight following the Civil War, their basic rights, their fundamental rights were deprived them, and the government needed to step in and bring about a rectification of those issues. When we look at other groups, which groups are being discriminated against, and what rights are being threatened? And ultimately, what can be done? Is it legal discrimination or is it social discrimination? And I'll leave that up to you to figure out. But those are interesting things to think about. If you think about groups that are struggling for civil rights today, obviously you have like I mean, probably one of the big issues today would be the transgender roles of transgender men, that transgender biological men that transition into the roles, gender roles of females, and then compete in female athletics. And then women are arguing, like, you know, with our instance with the swimmer from the University of Pennsylvania, that women are upset that their rights are being violated because they're not competing. They're competing against a biological man. They're not competing against biological women. And so, like, you know, we look at those three steps. And it's interesting, like, what can the government do? And is it a realistic fix? I think we're going to get an answer to those types of questions much sooner than some of the others. And obviously, athletics is important, but it's not as important as like marriage rights or you know, voting rights, those types of things. But it'll be an example of the Supreme Court or the you know, the court system using the laws that are in place to make a decision. And that will be interesting to see probably in the next 5 to 6 years, maybe even sooner, when that comes down the pipe. Okay, African Americans, probably the most identifiable group that's tied into the civil rights struggle. Obviously, you have the civil rights efforts following the world wars that culminate with the Civil Rights Act of 1964. And there's not really a racial group in the United States that probably has faced as much, I don't want to say that. African Americans face a lot of discrimination in the nation's past. Obviously, you know, you have the 3/5 compromise where African Americans are counted as 3/5 of a person. You have situations like the chattel system of slavery in the American South and in the American North for a period of time in which African Americans were property. African Americans were brought over to the United States, most of them against their will. I mean, you know, what, probably 98, 99% of African Americans that come over to the United States in the early days of the American Republic are brought over unwillingly, and sold to people. And so you see things like the Dred Scott decision, which we talked about. And the Supreme Court rules that African Americans aren't citizens, and they don't have the rights to sue the courts. They don't have the rights to any type of representation before the Supreme Court or before American law. And that's in 1857, which is, you know, shortly before the Civil War. We had that period of Reconstruction where I feel like we're just kind of repeating ourselves here, where we have the Reconstruction of Civil War amendments with 13th, 14th, and 15th Amendment. And then following Reconstruction, after 1877, you see another attempt from the South to limit the rights of African Americans. The first one you're going to see is the literacy test, in which voters are given a text to read, and they're not only asked to read it, but they're asked to interpret that text. What does it mean? African Americans are given very difficult texts when they're compared to whites. Like, you could have a poor white farmer that would come in and be given a Jack and Jill nursery rhyme, versus an African American could be given a passage from Revelation from the King James Bible, which is very, very difficult to read and understand because the language would be foreign. Think about some Shakespeare plays, those types of things where it's Old English, and the words mean different things, or maybe the words are unfamiliar to you if you would go through and read it. I don't know if you guys had to read Shakespeare growing up or in high school, but you read it and you're like, what was that, right? And so you have the literacy test. Well, in addition to the literacy test, you also have the grandfather clause, where you would have poor whites in the South that were illiterate, couldn't read or write. And so they felt like their rights were being limited through the literacy test. So the Southern states passed what is called the grandfather clause, which allows people with less literacy skills to vote as long as their grandfather had the right to vote. Obviously, if you're a former slave, your grandfather didn't have the right to vote, right? You would also have a poll tax, which was a tax that was applied per year to for the ability to vote. So, you know, you would have to pay $20 to vote or whatever. Typically, African Americans suffered from rates of poverty greater than whites, and so the poll tax was out of question. And then you would have white-only primaries that were on state levels. So your representatives to federal governments or whatever were only really available. The options were only really available to whites and not blacks. And so you have those things that come about. You also have Jim Crow laws that come out of the black codes, which are the legal separation of segregation of society. You have different facilities, you have different schools, you have different just separation of different social statements, just separation of blacks and whites in society. And the 1896 Supreme Court case, Plessy versus Ferguson, ruled that facilities could be separated on race. Those aren't necessarily a violation of the Equal Protection Clause, as long as they were separate but equal, right? But you know, those facilities weren't equal, and they were just separate. They were just different. And so those are going to be in place. You know, Jim Crow laws are going to be in place from 1877 until 1964. You have two different, the book talks about, this is almost more of a history lesson than a government lesson, but the book talks about Booker T. Washington and W.E.B. Du Bois, and their different approaches to bringing an end to segregation. Washington argues that blacks should accept inequality and work towards improvements in education until whites accept African Americans within their society. And Du Bois argued that blacks should work for equality using the tools available, such as the courts. And so in 1909, he founds the NAACP, the National Association for the Advancement of Colored People. And he begins to sue institutions along the idea of segregation and inequality along the 14th Amendment. And this is really, the NAACP is really where you're going to see the first headway made in the civil rights movement. Obviously, you're going to see famous court cases like Brown versus Board of Education in the 1950s, but you also have court cases like Gaines versus Canada in 1938. And Canada was the register at the University of Missouri. I think the gentleman's name was Charles Gaines, if I remember right, and he was an African American. He applies for admission into the law school at the University of Missouri, and is denied admission because of his race. And so Missouri doesn't have a law school for African Americans. Gaines is denied admission. And the Supreme Court rules that either schools in the South have to allow African Americans to join institutes of higher education, or they have to create an equivalent university for African Americans. And so a lot of places in the South start to create all Black universities, Black medical schools, Black medical schools, Black law schools, those types of things. Brown versus Board of Education, of course, in 1954, the Supreme Court rules that Plessy versus Ferguson is not constitutional, and that separate but equal facilities cause inferiority to the discriminated race. They find this through one of the findings is the Dahl test. I think the book talks about this a little bit, in which white children and Black children were shown identical dolls, either white dolls or Black dolls, but they're identical other than the color. And the children would prefer to play, children of all races would prefer to play with the white doll. And they would attribute positive characteristics to the white doll and negative characteristics to the Black doll. Like the Black doll would be naughty, where the white doll would be good, those types of things. And so it shows that, it showed the Supreme Court, or it showed medical researchers that that segregation was having a negative effect on the African American society. When you do have the final segregation of schools, some states segregate very voluntarily. Other states like Arkansas put up a huge fight. Central High in Arkansas, Little Rock, Arkansas, they basically nationalized mobilized the National Guard to prevent 9 African American students from integrating Central High. President Eisenhower is presented with a problem. Either he allows Arkansas to be in violation of a Supreme Court ruling, or he has to mobilize forces to go in and open up the school. Of course, he nationalizes the National Guard, so he activates them on a national level, takes them away from the governor, and he sends in the 101st Airborne to chaperone 9 African American students during that school year. And then the following school year, Little Rock school shut down. Lots of schools in the South will shut down. Virginia's going to shut down public schools instead of ending segregation for a long period of time, 2-3 years. And whites begin to create like private academies or homeschooling of whites only. And so, like, you know, the end of segregation in the South, it's a long process. You know, some people argue that it's still going on today. You look at things like voter ID laws, or that's the big one, voter ID laws. People will argue are aimed at reducing minority participation in voting. African Americans are typically more likely not to have a photo ID than whites. And especially along poverty lines, you know, the poorer you are, the less likely you are to have those types of documentation. So we have that. Talks about de jure segregation. So you have de facto segregation, which is just society, and then de jure segregation, which is just social practices. So like many neighborhoods required homeowners to sign paperwork not to sell homes to Black families, to segregate families. However, in 1948, the Supreme Court ruled that wasn't constitutional. However, they couldn't do anything because it was an agreement between individuals. But if those individuals would sue, let's say, so a homeowner does sell their home to an African-American family, the individual that would sue would not have a basis to be heard in court. Okay, I told you this was a long one. So this, it's not until 1967 that 54 years ago, that the Supreme Court ruled that interracial marriages were legal, and those marriages couldn't be regulated by states, that marriage was a fundamental right. That is Loving versus Virginia. In 1962, Congress proposed, and then eventually passes the states to ratify the 24th Amendment that brings an end to the poll tax. And then you have that, and then some states would continue to charge a poll tax on state elections, and it's not until 1966 with Harper versus Virginia Board of Elections that the Supreme Court ruled that poll taxes at any level were unconstitutional. And so, I mean, like, just going through this, you can see the levels that the extent that white society, especially in the South, and I know the South gets thrown under the bus for this, but there's good reason for that. Are required. I mean, they're doing things to really actively prevent civil rights. And so we have that. Okay. You also have civil rights movements that began, like SLCC, which is the Southern Christian Leadership Conference, and SNCC, which is the Student Nonviolent Coordinating Committee. So SLCC is Martin Luther King, African-American churches working together. Both of these groups are going to work with the NAACP. SNCC is more of your younger students working together. In the early 1960s, late 50s, early 1960s, SNCC is a multiracial organization. By 1968, more of a radical approach is taken by SNCC, and the white leadership is removed from that organization. And that's really when you start to see white people, young whites leaving SNCC and turning towards the anti-war movement, the war in Vietnam. Both groups are going to use more confrontational approaches than the NAACP, but both groups are going to work with the NAACP. NAACP is going to work more on the legal side of things. SNCC and SLIC are going to form protests. They're going to have direct action like marches. And of course, you have the most famous, probably civil disobedience case with Rosa Parks and the buses in Birmingham, in which we boycott the bus system in Birmingham. Martin Luther King forms, multiple marches. They talk about the march to Selma in the book. You have the Freedom Riders that are organized by SNCC, in which Black and white college students are going to take buses down from the north into the segregated South and face a reaction from the South. You have the Children's March in Birmingham, in which the public committee for public safety in Birmingham calls out the dogs and the fire department, and you have the famous you have the famous visuals from the 1960s, in which the African American children are marching down the street for civil rights, and the white fire department is hosing them down with fire hoses, or dogs are attacking people, and so you're trying to get that reaction from the establishment to attack these peaceful people, and it causes this sense of uneasiness in the viewers that see it. And so this direct action is very effective if the protesters get a reaction out of the establishment. If they just march down the street and nothing happened, then you probably don't get the end results that you're looking for. In 1964, the Supreme Court using the power to regulate interstate commerce says that interstate transportation needs to be desegregated. In 1964, we passed the Civil Rights Act, which outlaws government discrimination based on race, basically outlaws unequal application of voting qualifications by race, unequal discrimination for businesses that are open to the public. So you can't have a white section and a black section. It creates the Equal Employment Opportunity Commission that outlaws discrimination on hiring base, ethnicity, religion, race, all of that stuff. And then we talked about Selma and the riots in the Edmund Dulles Bridge. In 1965, we passed the Voting Rights Act, which allows for greater government oversight. Literacy tests are banned. Black voters begin to register and vote in higher numbers. At the same time, whites begin to register and vote in higher numbers. We have a little bit of controversy about 10 years ago in 2013, Shelby County versus Holder, in which the Supreme Court struck down some key parts of the Voting Rights Act, in which states no longer need federal approval to change laws. And so now you start to see the start of photo ID laws. You start to see limiting factors on early voting, mail-in voting, absentee voting, and those things are still going to go on. Those arguments for and against are still taking place. Okay, we talked about de jure and de facto segregation. There's still discrimination in the United States. However, much of it is de facto. It's just de facto. It's just poverty schooling. Schools are still regulated because a lot of schools are based on where you live. And so, you have situations like white flight in major cities in which economically advantaged whites are going to move to the suburbs, and they're going to live in places that might be economically unreachable for some minorities. You have those types of things. The women also had gone through a struggle for their civil rights. At the founding of the country, single women could own property, but married women could not. Once you got married, your property was transferred over to your husband, although your husband couldn't sell it without permission, and so forth and so on. The women's right to vote was kind of tied into the abolitionist movement before the Civil War. So in 1848, you had the women meeting in Seneca Falls, and they write what is the Declaration of Sentiments, which basically declares that women have the right to vote. They show the same rights as men. The book talks about Susan B. Anthony and Elizabeth Cady Stanton, and the connection between the women's rights movement and the temperance movement and the abolition movement. You have this weird combination of politically active women really kind of all working together. And you see this big split between the abolitionist movement and the women's movement with the 15th Amendment, when African-American men are given the right to vote and white women are left behind. And eventually you start to see the formation of women's suffrage groups. Okay, so you start to see the formation of women's suffrage groups and groups that are going to work towards women's equality. In 1869, you see Stanton and Anthony, they form the National Women's Suffrage Association. Lucy Storm forms the National Women's Suffrage Association. The difference between these two is that Stanton and Anthony are going to work for on the national level, and Stone is going to work more on the state level. Stone actually has a little bit more success early on. Utah is the first state to allow women voters to take part in federal and state elections. And neither one of them have overwhelming success. Some states allow women to vote in local elections, like Kansas is the first state to allow women to vote in school board elections, but they're not allowed to vote in state or federal elections. Alice Paul forms the National Women's Party, and she's much more, and this is like 1910s, early 1900s. She's going to use stronger tactics. They're going to picket the White House. They're going to have hunger strikes. They're going to chain themselves to the fence on the outside of the White House. And just much more in your face. It gets into the news, and people start to pay more attention. And one of the things that Paul demands is Alice Paul starts to demand equal rights for women across the board, not just with voting. And so because of Alice Paul and the National Women's Party, all of a sudden these suffrage associations that just want women's voting rights become more attractive to mainstream society, because Alice Paul is starting to become more attractive to women in general, like just, across the board. Like women are like, hey, we should have more than just voting. And so almost as a measure to limit the movement towards equality, the 19th Amendment gets passed in 1920. 19th Amendment's ratified, allows women the right to vote. In the 1960s, you start to see the support of the second wave of feminism with the Title VI of the Civil Rights Act that outlaws discrimination based on sex, and then the National Organization of Women start to support this idea of equal rights amendments. In 1972, the Equal Rights Amendment actually passes the Senate and the House, goes out to the states to become a constitutional amendment, and it doesn't receive its ratification in a timely manner. In 2020, Virginia actually is the 35th state to pass the ERA, but it's missed the deadline that was set in the legislation, and then also 5 states have revoked its passage, and so It's not going to become a constitutional amendment. Now it could in the future. I mean, I don't know if you have support for a ERA amendment at this point in the Congress, but we'll see what happens. Title IX is probably the most important and impactful part of women's civil rights. Title IX comes from the U.S. Education Amendment of 1972, which is just passed like normal law. And basically, it says that states, educational institutions that receive federal money have to spend equal money on programs for women and men. So athletics, there has to be equal money spent for women and men. And when this started to really come down and be enforced in the late 90s, a lot of schools cut a lot of programs, sporting programs for men to make up for the fact that so much money goes into like football. And you have that. You also have things like the glass ceiling, in which women, there's really not legal barriers for women to run companies or to move up the business ladder, but there's invisible barriers, or again, that idea of de facto discrimination against women. So you have things like the words like glass ceiling, in which there's an invisible barrier caused by discrimination, or women earn about 79 cents to the dollar that men do. Traditional jobs that are done by men, like garbage work, garbage collection, are paid more than traditional female jobs like daycare. In society, women are more likely to be single parents, to be left to raise children by themselves. Because of that, women face greater levels of poverty. Women are subjected to more cases of harassment at the workplace. You see like sexual harassment, the Me Too movement, and those types of things. Women are also more likely to be victims of domestic abuse. Women are also more likely to face laws of discrimination against their choices. Banning of abortion or limited healthcare options are seen by some as efforts to restrict women's rights. We talked about traditional male jobs paying more than women. Native Americans, 1884, Elks versus Wilkins, citizenship in the United States is denied to Native Americans. 1831, the Cherokee Nation against Georgia. The Cherokee Nation was not seen as a sovereign nation by the Supreme Court. And so then you're in this weird spot between 1831 and 1894 or 1884, in which, well, Native American tribes aren't sovereign nations, but then they're not citizens in the United States either. So what are you going to do? 1832, Worcester versus Georgia. Basically, the Supreme Court outlaws whites from entering tribal lands without permission, but then President Jackson forcefully removes from the Native Americans from their homelands east of the Mississippi, and that leads to the Trail of Tears and the death of thousands of the Cherokee tribe as they're relocated to the Indian Territory in modern day Oklahoma. You see the Dawes, you see different congressional acts that limit choices on reservation lands. It's not until 1924 that Native Americans are given citizenship. Those that are granted citizenship after the Indian Citizenship Act of 1924, and then 1940. So until 1940 that Native Americans are given, all Native Americans are given citizenship in the United States. So you can kind of see, just going through this, the book does a nice job, and I'm just going to kind of skip through this. The book does a nice job talking about like the Bureau of Indian Affairs, and the reaction to like the Wounded Knee and the Pine Ridge Reservation, and in the Indian movement of the 1970s, as they began to try to work towards civil rights. Native Americans face higher poverty rates, greater substance abuse rates than almost any other racial group. Native Alaskans are going to lose control of their lands when the United States annexes when the United States annexes Alaska, and then it's not until 1971 that there's a settlement made between Native Alaskans and the United States government. Native Hawaiians face some discrimination as well, where they lose native lands, and those eventually are given back, or some of them are given back in the early and mid 1990s. And you see the government organizations pop up that work with the U.S. Department of the Interior to meet some of the needs of Native Americans, Alaskans, and Hawaiians. Hispanics and Latinos, they're another racial group that face discrimination. Again, they're much like the Alaskans or the Hawaiians, where a lot of Latinos are absorbed into the United States with the annexation of Mexico, and then following the Mexican-American War. We see an increase in Latino population in the United States. Originally, those people are given, people that are absorbed into the United States are given citizenship in the United States, but their rights are very limited. We annex Puerto Rico, or Puerto Rico becomes a protectorate of the United States following the Spanish-American War, and then in 1917, citizens of Puerto Rico were given citizenship. The Great Depression leads to discrimination against Hispanics, and the fact that, or Latinos, and the fact that a lot of U.S. citizens are deported from the United States and the Southwest to make room for white Americans to take jobs. Following that, in World War II, we have the Bracio program, in which we encourage immigration into the United States from Mexico and from Latin America to fill the labor need left behind as America mobilizes for war. Book does a nice job of talking about Cesar Chavez and the United Farm Workers and their boycotts and their protests, and I'm going to ask you to read that on your own. 1994, you see Proposition 187, which the federal courts rule is unconstitutional, saying that states can't regulate immigration because immigration is a federal power. But it's like you can't ban children from attending public school because they can't prove residency in the nation, but you can ban them from attending a certain school because they can't prove residency within the school district. Arizona makes it a law to pass, making it legal to be in the United States without documentation, and the Supreme Court struck that down. But they did upheld the ability of police to ascertain the immigration status of someone, so they can ask for your immigration papers if they have reason to believe that you're in the country for as an immigrant or as an undocumented immigrant. Asian Americans also face discrimination. The book, I think one of the interesting things is the book historically refers to Asian Americans as the model minority, because they don't necessarily, Asian Americans, again, this is very stereotypical, are typically very academically focused and financially successful. So like the Asian American immigrants or people of Asian American background typically have higher levels of education and work, and financially they make more money basically. And so, like, in the 1800s, they're one of the first large, they're obviously one of the first large groups to migrate to the United States in the late 1800s to help with the construction of the railroads from California eastward. With the completion of that railroad, we see the passage of the 1882 Chinese Exclusion Act that prevents Chinese immigration for 10 years and prevents Chinese immigrants from becoming U.S. citizens. That bill is extended in 1892. And then you see things like California passing laws preventing all Asians from owning land in 1913. And then 1924, during all Asians were prevented from immigrating to the United States other than Filipinos, and Filipinos were part of the United States. World War II were a protectorate of it was a territory of the United States. In World War II, Japanese Americans are relocated from the West Coast to internment camps, and the Supreme Court ruled that was justified because of the war effort. And eventually, those individuals were given some restitution from the United States government. In 1974, Chinese students sued the San Francisco school district for not teaching English or for not offering English as a second language class. And therefore, they were denying equal educational opportunities, and they weren't protected by the the 14th Amendment. And the Supreme Court ruled in their favor. Again, today, you're going to see a lot of discrimination or discrimination cases that begin being focused on the LGBT community. Laws for a long period of time, especially, were aimed at male homosexuals, and it was it would have been basically suicide for gay men or even gay women. Although it was probably more acceptable for women to be gay or bisexual in the history of America, but like gay men would be subject to blackmail, and they would kind of operate on in secrecy. 1950s, you start to see the first organization of gay men begin to organize and work for gay rights. You see this sister group of lesbians do the same thing. 1962, you start to see you actually have a gay protest in Philadelphia. In 1969, it's kind of seen as the beginning of the gay rights movement, and that was with the Stonewall riots. The Stonewall was a hotel nightclub frequented by homosexuals in New York City. And the police basically raided the place, trying to arrest people for engaging in consensual same-sex relationships. And they rioted, and they forced the police out of the hotel, and they prevented the arrest of these individuals. And it was kind of seen as a rallying call for the gay rights movement across the country. So Stonewall is seen kind of as the place that begins. 1973, the American Psychological Association actually ends the classification of homosexuality being a mental disease or a mental disorder. 1994, under the presidency of Bill Clinton, you see the passage of Don't Ask, Don't Tell, where gays could openly serve in the military. And they would no longer be excluded because of their homosexuality. In Lawrence versus Texas in 2006, the Supreme Court ruled that states could not criminalize sex between consenting adults, regardless of their gender. So if two men want to engage in that, or two women, it couldn't be considered as a crime. 2015, we see the ban on same-sex marriages lifted, which causes a backlash in America's religious community, where we start to see states pass like freedom of religion acts or religious freedom restoration acts, and in which states they face strict scrutiny for these actions, but if they basically there's certain people in the Christian faith or in religious societies that are arguing that if they're forced to recognize same-sex relationships, or they're forced to recognize acts that they consider sinful, then that's a violation of their First Amendment rights of free exercise. And the Supreme Court has been hearing those cases for a while, and there hasn't been a definitive case. Although the Supreme Court is definitely starting to cede a lot of cases to the side of the religious conservatives. Civil Rights Act forbids discrimination of trans people based on as a form of sexual discrimination, and that will be interesting to see how the Supreme Court deals with that in the future. We see hate crimes based on somebody's gender or sexual orientation become crimes against people like that, classified as a hate crime, and that's called the Matthew Shepard Act. Matthew Shepard was a gay college student at the University of Wyoming that was brutally murdered, and basically his treatment or his murder was national news, brought to the forefront the treatment of gay individuals. People with disabilities also face discrimination. Going back all the way to the 1900s, like 1927, you have Buck versus Bell, in which the Supreme Court upheld that it was the state's right to sterilize people that they believed would likely have children that would become dependents of the state. And so you have this eugenics movement within the United States that comes about. But then in 1973, you have the Rehabilitation Act that basically makes it a federal crime to discriminate against people with different abilities. You have the 1990 case of the Americans with Disability Acts that provides more protections for individuals with disabilities. It talks about religious minorities and the facing of discrimination of Irish Catholics or Mormons or Jews or Muslims Muslims specifically after 9/11. Haven't had a huge court cases with that recently. Probably the biggest one again is this idea of conservative Christians having or believing that some of their rights are restricted because they have to recognize other people or comply with actions of the government. Burwell versus Hobby Lobby is one of those cases in which the owner of Hobby Lobby sued the government and the Affordable Care Act or Obamacare because he didn't want to provide contraceptives for women that were required by the Affordable Care Act, and the Supreme Court ruled in his favor that because he was a privately held company that has stated his religious beliefs, that complying with those mandates would have been a violation of his beliefs and his religions. And so that kind of gets us through these civil rights. I hope that it was kind of rambling and went on. I don't know if I added anything from what the book said, but there's a lot there. Maybe this will help you with the quiz. If there's that, if you have any questions, reach out to me. But otherwise, we'll see you with chapter 7 or chapter 6. See you later. Bye.